Hello and welcome to the lesson. The subject is corporate governance and ethics. We will continue with the topic internal corporate documents. And in our today's lesson, we are going to study the shareholder agreements. Shareholder agreements. Shareholder agreements. Now, shareholder agreements are also known as stockholder agreements. And these are internal corporate document. This is an internal corporate document. A shareholder agreement is an internal corporate document that outlines the rights and the responsibilities of shareholders of a company. So it is an internal corporate document. So a shareholder agreement is an internal corporate document that highlights the responsibilities and the rights of the shareholders of a company. And while they are not mandatory in Kenya, they are highly recommended, especially for small and medium-sized enterprises or companies with multiple shareholders. So what is the purpose of shareholder agreements? What role do they play? Now, the first purpose of shareholder agreement in Kenya is in relation to governance. Governance. Now, the agreement defines how the company will be managed and operated, detailing the decision-making processes, the voting rights, and dispute resolution mechanisms. That is the first purpose of this document. The second purpose is in relation to share transfer restrictions. Share transfer restrictions. Now, this it can include provisions. This document can include provisions restricting the transfer of shares to third parties, including what we call the preemption rights. That means giving existing shareholders the right of first refusal, or what we call the tag along and drag along rights. So the shareholder agreement can include provisions for share transfer restrictions. Share transfer restrictions. This document also contains rights and responsibilities. It highlights the rights and responsibilities of the shareholders. It outlines the rights and responsibilities of shareholders and such rights as entitlement to dividends, access to information, participation in decision-making process, and it also details the obligations such as capital contribution, adherence to confidentiality, those are obligations, and so on. So this document highlights the rights and responsibilities of the shareholders. That is the third purpose. 4, dispute resolution. Dispute resolution. This document can establish mechanism for resolving disputes among the shareholders, such as mediation or arbitration, or avoiding costly and time-consuming litigation. The document can contain dispute resolution mechanisms. 5. Valuation. Now, it can specify methods. This document can specify methods of valuing the company's shares, particularly in important cases like mergers, acquisitions, and buyouts, and so on. Valuation of companies, right, or shares, right? It can specify methods that can be used to value the shares of the company. Valuation of shares. So these are 5 purposes of share agreements. Let us now outline some of the key provisions of share agreements. Key provisions. The key provisions of share agreements. The first key provision is share issuance and transfer. Share issuance and transfer. Share issuance and share transfer. These are rules governing the issuance of new shares and the transfer of existing shares. That is one key provision of share agreement. Rules governing the issuance of new shares and also rules governing the transfer of existing shares. Two, there could be provisions on governance and management. Governance and management. Governance and management. Now, this refers to the procedures for electing directors, procedures for holding meetings, and procedures for making decisions. So that is the second key provision of the shareholder agreement. Governance and management, which refers to the procedures that should be put in place when electing directors. There are also procedures for holding meetings, procedures for making decisions, and so on. That's the second provision. 3. Dividend policy. The dividend policy. Dividend policy. Under this key provision, you may have guidelines for the declaration and guidelines for payment of dividends. Dividend policy. 4. Restrictions on competition. Another key provision is restriction on competition. These are non-compete clauses to prevent the shareholders from competing with each other. Right? Competing, or shareholders competing with the company. Restrictions or clauses on competition. That is a key provision of the shareholder agreement. Another provision could be in relation to confidentiality. Confidentiality. These are provisions to protect the company's confidential information, because the shareholders may have access to information of the company, so they are bound not to reveal that information to third parties without the permission of the company. Confidentiality clauses or provisions. Number 5. 6. Deadlock provision. Deadlock provision. These are mechanisms for resolving disputes if if the shareholders cannot agree. We say that there could be one purpose for the shareholder agreements is to resolve conflicts that may arise between shareholders or between shareholders and the company. But there also need to be what we call deadlock provisions within the shareholder agreements that specifies the mechanisms for resolving disputes if the shareholders cannot agree. Deadlock provisions. 7. Exit strategies could yet be another key provision of shareholder agreement. These are procedures for shareholders to exit the company, such as buyouts, such as forced sales, and so on. There ought to be procedures on exit strategies. So these are 7 key provisions of shareholder agreements. Now, it's important to note that shareholder agreements are private contracts between shareholders of a company. It's a contract between the shareholders of a company. These agreements are not required by law. They are not legally binding. They are not required to be filed with the registrar of companies, but they are legally binding to the parties who sign them. You understand? That is the legal status of shareholder agreements. They are private contracts between the shareholders of a company, and they are not required to be filed with the registrar of companies, but they are legally binding between the parties who sign these contracts or agreements. And shareholder agreements are important because they provide clarity and certainty regarding the rights and responsibilities of and obligations of the shareholders, which they can help. They can also help prevent disputes. These agreements can ensure smooth operation of a company, and they are particularly uh, valuable in situations where the company's constitution does not adequately address specific needs and concerns of the shareholders. So that's the end of today's lesson, where we have studied shareholder agreements. We've said that shareholder agreements are internal corporate documents that highlight the rights and responsibilities of shareholders of a company. We've highlighted 5 purposes. One is in relation to governance. Number 2, share transfer restrictions. Number 3, it highlights rights and responsibilities and obligations of the shareholders. Number 4 is in relation to dispute resolution. And lastly, it helps in specifying the methods of valuing the shares of a company. We've gone ahead to identify the key provisions of shareholder agreements. The first provision is in relation to share issuance and transfer. This agreement highlights the rules, specifies the rules of issuing and transferring of issuing of new shares, and rules in relation to transfer of existing shares. That is number one. Number two is in relation to governance and management. This is a provision in relation to governance and management. We say that the share agreements can provide the procedures for electing directors, holding the meetings of the shareholders, and also it can specify the procedure for making decisions. Number four is dividend policy. Five is restrictions on competition. There is also a provision on confidentiality, deadlock provisions, and exit strategies. Here is your today's assignment. 1. What provisions are included in the shareholder agreements regarding the transfer of shares? 2. How does the shareholder agreement address the issue of dividend distribution? 3. What mechanisms can be put in place to handle disputes among shareholders in shareholder agreements? 4. How does the shareholder agreements protect minority shareholders' interests? 5. What are the agreed upon conditions under which shareholders can exit the company? That is your today's assignment. Bye.